Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.
Thank you for listening to this St. Louis on the Air podcast brought to you by Lindenwood University's Hammond Institute for Free Enterprise, examining market approaches to help solve economic and social issues, hammond.institute.
Welcome to St. Louis on the Air. I'm Don Marsh. Today we're going behind the headlines. All week, beginning with our broadcast on Monday and continuing on our website, we examined civil asset forfeiture. That's the law enforcement tool used to seize assets, cash, and property believed to be associated with criminal activity. Often, those assets are kept by law enforcement, even when no charges are filed. This week, the U.S. Supreme Court stepped in with a major ruling impacting that process. Joining me in studio to talk about it is Bill Freivogel, that is. He has reported all week on our online civil asset forfeiture series. Bill, the Supreme Court has ruled that the Constitution's ban on excessive fines applies to the states. What does that mean to the forfeiture process?
Well, it means that states such as Indiana, where that case came from, cannot impose seize a piece of property or seize cash that's so much out of proportion to the wrong that the person did. So this involved a case by the name of a person by the name of Tyson Timms. He lived in Marion, Indiana, and he had gotten hooked on opioids, and he ran out of money to buy opioids, got hooked on heroin. His father died. There was a life insurance policy of $70,000. He spent $45,000 of it on a Land Rover. He then sold some drugs out of the Land Rover, got caught by the cops, and prosecuted. The maximum fine for his prosecution was $10,000, but they nevertheless held on to the Land Rover and said it should be forfeited in the process. So is it an excessive fine for police to hold on to a $45,000 Land Rover when the maximum fine for the thing that Timms had done was only $10,000. Some lower courts in Indiana said, yes, that's an excessive fine. The Indiana Supreme Court then said, well, the Eighth Amendment, which is where the excessive fines prohibition is in the Bill of Rights. The Eighth Amendment's never been applied by the Supreme Court to the states, so we don't have to follow. In Indiana, we don't have to follow the Eighth Amendment, that part of the Eighth Amendment.
But how about Missouri?
Missouri does not have the same kind of prohibitions. There were only about four. Indiana was one of about four states. I think maybe Michigan, Montana were amongst the others that said the Eighth Amendment hasn't been applied to the states, so we're going to ignore it. Well, the Supreme Court said it's too late for that. The excessive fines clause, just like the cruel and unusual punishment part of the Eighth Amendment, is fundamental to our concept of ordered liberty. It's been in the Constitution ever since the Bill of Rights was written. It goes back to the Magna Carta and to the English Bill of Rights in the 1600s. It's fundamental to our whole Anglo-Saxon rule of law. So that's what Ruth Bader Ginsburg wrote that opinion for the court. Indiana, you've got to follow the Eighth Amendment excessive fines clause.
Is this a first step, though, in getting at the overall problem with the forfeiture situation?
Well, it's actually a fairly limited step. I think some of the media stories after the Supreme Court opinion sort of exaggerate how big a step it was. I interviewed a person, David Smith, he's a Virginia lawyer, he's a real expert on this, who said it really didn't have very much effect. For example, in our stories that we talked about on Monday, Don, we talked in particular about two counties in Missouri, Phelps County down by Rolla and St. Charles County, and they are hauling in the biggest takes of cash through the civil asset forfeiture process, stopping people along Highway 44 and Highway 70 and taking the cash and then going through a federal process and getting most of it back then to spend on their own needs. police cars, jails, etc. That process is not affected at all by this Supreme Court opinion. The Eighth Amendment already applied in that situation because this was, they went through the federal process, so the Eighth Amendment was already applicable to the federal process. And just yesterday, the state auditor filed her annual report on asset forfeitures in Missouri. And it showed that $9 million was seized in property was seized by police and sheriff's deputies this past year. That was up $2 million from the year before, so that's 2018 versus 2017. And of the $9 million, $5 million of it was seized in St. Charles County and Phelps County. $3 million in St. Charles, $2 million in Phelps. And out of those, there were a total of 64 stops. There were only criminal charges filed in 6 of those cases. So in most of these cases, no criminal charges are being filed, no drugs are being found, but the money is being seized and then used for law enforcement purposes.
So that's what captures everyone's attention, is the fact that no charges are filed,
right,
and the cops keep the money.
So even though the Ruth Bader Ginsburg's decision for a unanimous Supreme Court on Wednesday doesn't have a direct impact on that, it may have a psychological impact. Tony Messenger of the Post-Dispatch had an interesting column in this morning's Post-Dispatch about a reform bill that Shamid Dogan of, I believe it's from Baldwin, has been pushing a number of years in the legislature with little success, but according to Tony, it was passed unanimously out of the Dogan's House committee yesterday, and it would cut off this entire route of sending that Phelps County and St. Charles County have been using, of sending these millions of dollars through the federal process so that they can get it back and spend it on law enforcement purposes. We'll see if that passes the legislature. It hasn't the past 2 years.
The Messenger says that the Supreme Court decision puts more teeth in the whole criminal reform process.
Yeah, I think that's true, and it applies outside of civil asset forfeiture too. It applies to anything where there's excessive fines. So think back to Ferguson, to these municipalities that are charging exorbitant fines in order to fund municipal. Their municipal projects. Applying the excessive fines caused the Eighth Amendment to the states could affect that kind of situation. Tony's been writing a lot about people who end up with big bills for having been boarded in jails around Missouri and then not being able to pay off those bills. It could affect that kind of a situation as well.
That is really striking, that particular part of the story. And they're all kind of linked together, kind of linked together. But to think that people are charged room and board when they're in jail, and if they can't pay it, it's back to jail where the bill goes up.
It's back to jail, yes. Yeah. I mean, those have been great stories that I think Messenger has had. And it looks as though we're moving towards reforms in that area as well.
Yeah. What do you make of a unanimous decision by the Supreme Court on this?
Well, it's actually not surprising, because this is one area where you get the conservative libertarians like Justice Thomas and Gorsuch on the one hand, and you've got the liberals like Sotomayor and Ruth Bader Ginsburg on the other, all agreeing, because they all take this sort of libertarian view that the police are. This really amounts to policing for profit. Mm-hmm. That when you allow the police to seize this property and then use it for their budgetary needs, that the police departments have got sort of an unclean hands. They want to seize as much property as possible so that they have it for their needs. Mm-hmm. And in places like Phelps County, they have a new jail. They've got a bunch of new police cars, shoot, don't shoot, range for officers, lots of weightlifting equipment, a whole new courthouse, a whole new courtroom. So it's very important to they consider it to be a godsend.
They want it to continue, obviously.
Yes.
There's
Yes,
no question about that. Where has the Supreme Court stood on this issue in the past? It has ruled in the past on civil asset forfeiture.
It has ruled in the past. We talked a little bit on Monday about the case from the 1990s. Where a couple in Michigan, the Bennis's, John Bennis used the family car to consort with prostitutes. His wife, Tina, didn't know about it. The police took the car. Tina said, "Hey, I'm innocent in this one. I'm the victim." And the Supreme Court said, "No, it's actually the car. This operates on the legal fiction, and it's actually the car that is the criminal." And so, Tina, you may be innocent, but the car was criminal, and they were taking the whole car.
So the bottom line to the Supreme Court ruling yesterday, although it was indicated that it was going to have a dramatic effect on asset forfeiture, certainly not in Missouri going to have much of an effect at all. No money's going back to these people who were not charged, anything like that.
No, it won't directly have any effect in Missouri, but indirectly, if Shamed Dogan's bill passes, and it's what Tony Messenger outlines it to be, to cut off this whole federal route of sending the money through the feds and getting it back for the state law enforcement to use. That if it adds momentum to that reform process, it could have a big effect.
Yeah. Well, that's what we'll be watching. Anything else that we should be looking for with regard to where this is all going?
Well, it seems. I'd say it would seem as though this whole subject is getting additional attention and additional momentum. It seems as though about every 3 or 4 years there's like another push for reform. Maybe this will lead to some reforms within Congress. There have been proposals in the past that would, try to disconnect the forfeitures from the law enforcement spending, so that the officers who are seizing the property don't have unclean hands trying to get a hold of the property.
And with some of the new blood in Congress these days, there's a likelihood that they could move in that direction, try to.
Right. Charles Grassley, the conservative Republican from Iowa, is a big supporter of that kind of reform.
All right. Well, Bill, thank you for bringing us up to speed on where we stand now that the Supreme Court has ruled. Not much change here, but stay tuned and keep your eye on the legislature.
Yes.
Bill Frauenvogel, thank you so very much for taking us behind the headlines. Always great to see you. This is St. Louis on the Air and St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.